Hi guys, welcome to my channel once again. It's bartalkwithola and my name is Nkemdilim. That's where the Ola comes from, Nkemdilim. Today I want to discuss a very important topic. All my topics are always very important. It is actually. So I want to talk about jurisdiction today. Very important, yeah? Jurisdiction. Let's talk about jurisdiction. I just want to explain in the simplest terms what the concept jurisdiction actually means and how you can best understand it as a lawyer, as a layman, or as a law student. So let's talk about jurisdiction. To explain jurisdiction, I'll talk about locus standi. Locus standi or locus standi is the right that you have to come before a court to ask for something. The right for you to be heard by the court. That's locus standi. That's your right of standing before the court. But jurisdiction, on the other hand, is the right that the court has to actually decide your matter. Like the lawful authority that the court has to decide your matter, to adjudicate on your case. That is what jurisdiction means in the simplest terms. Jurisdiction is the power of the court to adjudicate. It is the lawful authority that is conferred on the court to actually preside over and decide matters before it. And it could be, there are different dimensions to jurisdiction. If we look at the territorial dimension, territorial jurisdiction means that the rightful location or jurisdiction where you're supposed to institute your action. Now, let me explain that. For instance, in criminal matters, there's territorial jurisdiction. That means that you can only institute the crime in the jurisdiction where it happened. That is in the judicial division where the crime happened. So if a robbery has been committed in Ikeja, you have to institute it at the Ikeja High Court because it happened on the mainland. The same thing with if a matter happens in Oyo State, if a crime is committed in Oyo State, for instance, you cannot go to Ogun State to institute the matter, the criminal matter. You have to institute it in an Oyo State High Court, the court that has the appropriate territorial jurisdiction. So that is territorial jurisdiction for you. In divorce cases, for instance, jurisdiction is one in Nigeria. So that means that once you've lawfully been married in Nigeria, you can institute a divorce proceedings in any court in Nigeria. So you could have gotten married in Kano and then you come to Lagos to institute your proceedings, your divorce proceedings, your divorce petition. It's allowed. The instance of divorce, jurisdiction is one, singular, all over the country. So that's territorial jurisdiction. Then we have what we call substantive jurisdiction and procedural jurisdiction. For substantive jurisdiction, we're talking about the subject matter before the court and where can it be instituted. For instance, if there's a family court in a judicial division and you have brought an issue of maybe child welfare or child custody or maybe indecent assault of a young child, that should go to the family court. So not institute that kind of matter in maybe a criminal court or a revenue court or some other specialized court. It should go to the family court. That's substantive jurisdiction. That's jurisdiction that derives from the subject matter before the court. For instance, magistrate courts can adjudicate over matters that have a monetary value of below 10 million naira. But 10 million naira and below. But once it's above 10 million naira, you should institute it at the High Court. That's substantive jurisdiction. Because it is the subject matter before the court that will give rise to the court's jurisdiction. And then we have procedural jurisdiction. That's a jurisdiction that is prescribed based on some requirements as regard the procedure of instituting matters before the court. For instance, pre-action notice. So there are some matters that you cannot bring to court if you have not given, the opposing party or the defendant pre-action notice, adequate notice that you want to institute the matter. For instance, NNPC, if you wanted to sue NNPC in Nigeria, you have to notify them ahead that you're going to sue them. And in some cases, there are a certain number of days that you're supposed to give that, okay, I'm giving you 45-day notice. After 45 days, if you don't do anything about this matter, I'm going to court. So you need to give them pre-action notice. So if that is the case with the matter that you're bringing, if you don't do what you're supposed to do, if you do not issue that pre-action notice, the court will lack the power to hear you. So the court will lack the power to hear you. Another one is res judicata. Res judicata means It's a constitutional provision actually. It means res judicata means that already decided. So if a matter has already been decided by a court of competent jurisdiction, you cannot bring the same matter before another court to decide it. The same matter, same flavor, same subject matter, same everything. You can't bring it before another court to decide it all over because the matter has already been decided, res judicata. So in that case, the court will lack the jurisdiction to hear you because the matter has already been decided. That's res judicata. Then statute barred matters. Those are matters that are already statute barred. There are some matters, there are some actions that the law has prescribed the time within which you can bring it. For instance, the law could say that if someone owes you a debt and you want to recover it using litigation, you can only bring it between the period that you discover that this person is not going to pay and 5 years after that. So after 5 years, the matter becomes statute barred. That means that you can no longer sue on that matter because the law gave you a space of 5 years to only sue. So the matter becomes statute barred if you do not sue within that period. So bringing that kind of matter before the court will lack jurisdiction to hear you because it is already statute barred. It is already statute barred. Most criminal matters are not statute barred anyways, but the earlier the better. But for some civil matters, there are some time frames prescribed by law within which you can bring them. If you don't bring them within that time, they become statute barred. So those are examples of procedural jurisdiction. The easiest way to find out if a court has jurisdiction over a matter is to check the enabling law of the court. That is the act of the law that established the court. For instance, if you check the Federal High Court Act, it will tell you that the Federal High Court is empowered to hear such and such and such matters. So matters that are excluded cannot be brought before the court. The court lacks jurisdiction to hear such matters. For election petitions now, there are some courts or tribunals that are already prescribed that can hear them. So if you don't take it to those courts, whichever court you take it to will lack jurisdiction to hear or decide them. So for instance now, the NIC, National Industrial Court, is empowered to hear all labor disputes. So for instance, if you now take a criminal matter to the National Industrial Court, any judicial division now, you cannot be heard because it's not a labor dispute, it's a criminal matter. So that's how to find out jurisdiction in the easiest way. So there are some other ways such as, the enabling law of companies or the defendant, the prospective defendant. For instance, if you wanted to know if an NNPC has to be given pre-action notice, for instance, before you can sue them, you need to go and read the enabling law. The law that instituted or established NNPC will show you that if anyone has a grievance against them and you want to sue them, you have to give them a 45-day notice, a 10-day notice, pre-action notice before you take them to court. So that's how to find out jurisdiction. That's how to find it. You'll see that it's a comprehensive affair. You cannot just read the law of the court without reading, other laws that are affecting, your prospective defendant or your prospective co-litigant or respondent, as the case may be. So that's how to find out jurisdiction. Jurisdiction can be raised at any time, especially substantive jurisdiction, but procedural jurisdiction must be raised timely. Substantive jurisdiction can be raised at any time before the court. So even if, jurisdiction is so important that you can raise it for the first time at the Supreme Court. Yes, the matter could have gone from High Court, Court of Appeal, or Trial Court, whichever the court, Court of Appeal, and then Supreme Court, and that's where you're raising the issue of jurisdiction. The court still has to suspend all other matters, hear that preliminary objection, or hear that notice of objection as to jurisdiction, and decide on it before they can go on with the matter. So jurisdiction can be raised at any time, but it's best to raise it as soon as you discover it, as soon as there's a need for it. So as regards substantive jurisdiction, you can raise it at any time, but procedural jurisdiction has to be raised timeously. Thus, the court will assume that you're waiving your right to oppose based on jurisdiction. For instance, if you sue NNPC without a pre-action notice, I'm using that example because that's the earliest that I found out about pre-action notice, as far back as, say, 2011. So it readily comes to mind. So there are other examples. So if, for instance, you did not give NNPC pre-action notice and you sue them and they appear in court and they do not bring a preliminary objection that they were not issued pre-action notice, the court will deem it that they waived that right. That means that the court will assume that that person knows that they can oppose the jurisdiction, but they are waiving it because they want the matter to go on. So the court will deem it waived. Now, jurisdiction can be raised by the court itself, because anything done without appropriate jurisdiction is done in futility. That means that the court just had an academic exercise or just went on a fruitless traverse. So the court will not want to do that. So even if you do not raise the issue of jurisdiction, the court can raise it, and then you can also raise it. So jurisdiction can be raised by both the parties and the court suo motu. That means the court on its own. Now, in a very popular decided case, Madukolu and Nkemdili, the court already established the three most important legs of jurisdiction. That the way for you to check and to find out jurisdiction is to look at these three things and be sure that you are clear of them, that you have satisfied those things. The first thing is that the constitution of the court must be correct and no member must be disqualified for any reason. Constitution of the court regarding the number of the bench, the members of the bench. So for instance, there are matters that must be heard by at least 3 justices. Those are at the Court of Appeal or at the Supreme Court. There are matters that must be heard by at least 5 justices. There are matters that must be presided over by at least 7 justices. At the High Court is just 1 judge. At the Court of Appeal, 3 judges. So there are matters that all the 3 judges must be complete. They must be sitting on the matter, and no member must be disqualified for any reason. So after they are complete in number, all of them must be competent under the law to actually sit on that matter. So for instance, the law might say that at least one of the 3 justices that will sit on this matter must be well versed or learned in Sharia law. So if none of them is learned in Sharia law now, they have failed the test of jurisdiction. So that's what I mean by none must be disqualified by any reason whatsoever. So that's the first leg of jurisdiction. The number of the members of the bench must be complete according to law, and each of them must be competent. They must not be disqualified for any reason. The second leg of jurisdiction, according to Madukolu and Nkemdilim, is that the subject matter before the court must be one that the court has the lawful right to adjudicate upon, and nothing in the case must, disqualify the court from adjudicating upon it. That means that the subject matter brought before the court must be within the court's jurisdiction, and no feature of that subject matter must be disqualifying the court. For instance, now, if there's a specialized court such as a revenue court, you cannot take a matter of assault and battery to a revenue court. That means the subject matter disqualifies the court from adjudicating upon it. That's one. And 2 is that even if the subject matter is one that can be brought before the court, nothing must disqualify the court from sitting over it. If we were to take an assault and battery matter before the revenue courts, they are disqualified to adjudicate upon it because that subject matter is not within their jurisdiction. Now let's say that you take the matter to the appropriate court. Now no feature of the matter must disqualify it, in the sense that if the matter is statute bad, even though it is within the jurisdiction of the court will not hear it because it's statute bad. If you've not issued pre-action notice now, and the matter is a matter that should be heard by the court will still not hear it because you've not issued pre-action notice. So you see that this combines both procedural and substantive jurisdiction. Very important. So the second leg of Madukolu and Nkemdili's principle of jurisdiction is that the subject matter must be within the jurisdiction of the court, and no feature of that subject matter must be disqualifying or must disqualify the court from adjudicating upon it. The third leg is that the case must have been brought to court by due process after satisfying all relevant provisions, precedents, conditions precedent. That means that if the court says that before you bring this matter, do this. Before you can bring this matter, you must have exploded here. Before you can bring this matter, it has to be brought by way of a petition. It has to be brought by way of an originating summons. It has to be brought by way of a motion. You have to fulfill all those conditions, precedents, and all those procedures for instituting the matter before the court. That's the third leg. It means that the matter must be brought properly before the court. Now, let me go over it. According to Madukolu and Nkemdilim, there are 3 legs of jurisdiction. That's how to easily establish jurisdiction, and all the legs, must be fulfilled. All the legs must stand together before we can say that the court has jurisdiction over a matter and they can go on. And those are that: 1, the required number of members of the bench must be complete to adjudicate over the matter, and no member must be disqualified for any reason. 2 is that the subject matter must be within the jurisdiction of the court, and no feature of that case must disqualify the court from adjudicating upon it. And 3 is that by bringing the matter must be brought according to due process and all relevant conditions precedent, for the court will be said to have assumed jurisdiction over the matter properly. So that's a Madukolu and Nkemdilim for you. Please don't forget it, especially if you're a law student or a lawyer. It is the easiest way out for you to establish jurisdiction or to object to the jurisdiction of a court in any matter. And how do you object to jurisdiction? You object by bringing a preliminary objection, a notice of preliminary objection. As soon as you discover that fault, once you have served an originating process, you file your preliminary objection. Very important, file it immediately. So before the court will even do anything, let the court know that you can't even do anything in this matter because you don't have jurisdiction. Very important. The court treats preliminary objection as a matter of importance because essentially you are telling the court, shush, you can't speak. Shush, sit this one out. So that's exactly what you're telling the court. So the court will first address that before they go on in the matter. So very important. So you file a notice of preliminary objection and a written address, or you can file a motion on notice with your affidavit and written address, raising a preliminary objection to the jurisdiction of the court to adjudicate the matter. Now, if the court finds that it doesn't have jurisdiction, what does it do? It strikes out the matter. It doesn't dismiss it because it's not heard on its merit. It strikes out the matter, throws it out entirely. So that's what happens when the court decides that it does not have jurisdiction over the matter according to your preliminary objection. So that's all I have to tell you on jurisdiction for now. Please subscribe to the channel, like the video, and leave me comments. What have you learned in this video? And if you have any further questions, shoot me a mail at houseoflivingstones@gmail.com or leave me comments in the comment section. I will see you in my very next video. Toodles.